From a reckless driver endangering lives during a high-speed escape.
The allegations are that the defendant was in a property damage crash at a McDonald's and fled the scene. He ultimately struck a sign, hit a boulder, and wrecked the car. He had visible injuries at that time. The 1-year-old was in the vehicle. All of the airbags deployed.
To a young woman caught for theft.
It is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. Is that correct?
Here are 7 moments where Judge Simpson ensures offenders are held accountable for their actions, starting with Mr. Kinberger, who recklessly endangered his child while fleeing the police. The audacity to ask for a lower bond is crazy. Let's watch this.
All right, thank you. Thank you, sir. Court calls case People versus Kane Kinberger.
This is the public defender, Hannah Apple, appearing on behalf of Mr. Kinberger. Will you please state your name for the record?
Your Honor, we are asking for a very brief adjournment. We do not have discovery in this case yet. I did receive the police report just this morning from Ms. Londy, but I still need a chance to review that and the body cam once that's received.
Probable cause conference will be adjourned January 16, 2025.
Your Honor, may I briefly address bond? Your Honor, we are asking the court for a consideration of a release on a personal bond, scram tether, and in order to community corrections outpatient treatment. Mr. Kinberger discussed with me his need for treatment, and he's asking the court to consider that so that he may begin enrollment. I met with him yesterday. He advised me that he has enrolled in the Dawn Farms program in the jail, but is obviously on a wait list at this time, as well as AANA. He is the sole provider for his family. His girlfriend is 5 months pregnant, and he does have 2 other stepchildren that provides for. He does work full-time in Wayne at Colmac. He's been employed there since September, and he works 6 a.m. to 2 p.m., 2:30, I'm sorry. So he would be available in the evenings for outpatient treatment and would abide by all bond conditions and any testing or scram tether that the court would order.
Respond to the people.
First, I have 2 questions. First, could the court please tell me what the bond is currently set at?
I believe it is 100,000 10%.
And that is what my office had requested, was a $100,000 bond. My second question is, does the court have a copy of the bond information form that my office?
I do.
Thank you. In this case, the defendant, first of all, is charged operating with the operating while intoxicated with an occupant under the age of 16 and with a 1-year-old child in the vehicle. And furthermore, if the court has reviewed the bond information form, it will know that this is a serious risk to the public in this case. The allegations are that the defendant was in a property damage crash at a McDonald's and fled the scene. He ultimately struck a sign, hit a boulder, and wrecked the car. He had visible injuries at that time. The 1-year-old was in the vehicle. All of the airbags deployed. Then, while being transported to the hospital, he tried to wreck the patrol vehicle by grabbing the steering wheel as the trooper was operating it. I'm sure the court's familiar that MSP troopers, they don't have a cage in the back. The person rides next to the trooper in the passenger seat. So he reached over and tried to grab the steering wheel, while the trooper was driving 85 miles an hour. Very dangerous. People are requesting that the bond be continued at the $100,000 that we've already requested and been deemed appropriate by the magistrate.
Anything else?
I have nothing further, Your Honor.
I didn't think so. Motion for bond reduction is denied. Bond will continue.
Judge, I apologize. What date did you set it for?
16.
Thank you.
While Mr. Kinberger's reckless driving endangered lives on the highway, here's Mr. Douglas, accused of strangling a victim. It's outrageous how some would go that far to inflict pain on another and think they'd just go free without serious consequences.
Mr. Douglas, could you please state your name for the record?
Quentin Douglas, Jr.
Thank you, sir.
Your Honor, I did sign a request for an adjournment in this matter. We are still waiting on some discovery. I have spoken to the APA regarding that discovery. When I read the police report, because I just reread it, and it does appear that he made a 911 call. I'm asking for that 911 call. She has requested it. She's going to request again, is what I've been told this morning, because she believes she has everything. But based on my review of the police report, she does not. So we're just asking for a adjournment for that matter. And when appropriate, Your Honor, I'd like to address bond.
Your Honor, I do just want to clarify, I have requested all of the 911 calls related to this incident. There are 3. Dispatch says that I have received all of the calls for this incident. I will ask them to check again, but at this time, I do believe that I have everything that dispatch is in possession of. I will just dot all my I's and cross my T's, but understood. I believe at this time there is nothing additional to hand over.
January 16th, 2025. 9 a.m. Bond continued. Well, bond, go ahead.
Thank you, Your Honor. So you asked me to reach out to the Housing Commission because he has Section 8. He gave me the wrong name, but the individual that I was able to speak with, she says that he can come there. They haven't done anything. The keys are his. This is his apartment. I did request that they provide me an email or something along that nature so I can forward it to the court. I tried to contact them again this morning to get that email, Mr. Douglas. I don't know if they just weren't in, but they did not pick up. But they are indicating that he can come home, Your Honor, if the court will allow it. If I put it in.
Is the alleged victim a resident there also? Or?
No, Your Honor.
All right, go ahead.
And so, Your Honor, we are requesting that he be released untethered to his home, Your Honor.
Response.
My understanding, Your Honor, that he has a hold out of MSP and a pending OWI out of 14B. Additionally, he has a prior FA, multiple A and Bs. But in this particular case, we requested $100,000 cash surety because he strangled the victim, punched her multiple times, came at her and tried to hit her with a cane, then hit her in the legs with it. He was angry at the victim because she did not have sex with him. I don't think that a reduction is especially given the fact that he's at 5,010%.
Your Honor, up until recently, my client was homeless. He's indigent. So there is no way he can come up with 5,010%. Without the help of Avalon, he wouldn't even have a house to live in right now.
Motion for bond reduction denied. Bond will continue.
Unlike Mr. Douglas, who faced the consequences of his violent assault, this time it's Mr. Schwartz, caught up in the all-too-familiar cycle of drug abuse. It's pathetic how these offenders know the dangers involved with drugs and still do it anyway.
Court does call the case. People versus Scott Schwartz. Recall.
Sorry, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Schwartz. Sir, could you please unmute and state your name for the record?
Scott Schwartz.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant will be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed, and no objection the same day. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor, and Mr. Schwartz would like to accept that offer today.
All right. Schwartz, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Scott Schwartz.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, you would be scheduled to be sentenced before Judge Freshour in the 1484 District Court. You understand that?
Yes, sir.
Understanding all of that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I'm currently incarcerated, so.
Yes. Okay, so no, I got you. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
On August 30th, 2022, at the location of 9825 Burmeister Road, Bridgewater Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did.
Did you use it?
I had intentions on to.
Okay. But at that time, you hadn't used it?
No.
All right. And you knew what you had in your possession was methamphetamine?
Yes.
All right, taking the plea to the higher charge of possession. Counsel, have support complied with the court rule. Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Anything you want to say before I do impose sentence?
I would just ask for a sentence of the statutory minimums as well as time served, Your Honor. It is my understanding he has about 2 years of credit in the MDOC.
You've been in MDOC 2 years, sir?
Actually, 29 months.
Got it.
So almost 2.5 years, sir.
Okay. Anything you want to tell me before I impose sentence, sir?
No, sir. Thank you very much for taking my plea.
Not a problem. Fines and cost of $125, which is the state minimum. I'll sentence him to 365 days. Incarceration credit, 365 days. Thank you.
Thank you, Your
Thank
Honor.
you, sir.
Here we have Mr. Kurt Bender facing charges for substance abuse.
Good morning, Your Honor. Sanford Shulman, P43230, appearing on behalf of Kurt Bender. Mr. Bender is on video. Mr. Bender, can you introduce yourself?
Kurt Bender, Your Honor.
Thank you. All right, I have before me a plea form that indicates that he's going to plead guilty to the charge of use of cocaine to 1 year. Upon a successful plea to that charge, count 1 would be dismissed. There is a sentencing agreement to 7411 status and a term of probation. While that's on there, I cannot bind the sentencing judge to that agreement.
That's
right.
the correct statement of the agreement. Thank you.
And Your Honor, that is the entirety of the agreement as well.
All right, very good. Bender, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name for the record.
Kurt Bender.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
October 15, 2024, at the location of West Michigan Avenue near North Lewis Street, City of Saline, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
And did you know what you were using was cocaine?
Yes.
Counsel, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
At 9 a.m. before Judge Freshour.
January 28th, 2025, 9 a.m. before Judge Freshour.
This time we have Josephine Bartlett, accused of lying to the police and manipulating the justice system with false information, which is a crime you don't just commit and face no consequences.
That is what the court does have in front of it. All right. Ms. Bartlett, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name for the record.
Josephine Bartlett.
All right, Ms. Bartlett, it is this court's understanding that you're going to be pleading guilty to the charge of false report of a misdemeanor. That itself is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. You understand that? You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? Understanding all of that, still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
That's correct. I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
I understand.
You understand you're giving up your right to appeal of right.
I do understand.
Are you on probation or parole?
I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
I am.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
August 22nd, 2022, at the location of 520 North Ashley Street, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do? Did you make a call to the police?
I did.
What happened that makes you think that you're guilty of this offense?
A crime did occur, but the information that I provided to the police was false.
Okay. False in what way, ma'am?
Your Honor, I could clarify, she falsely.
Yes, go ahead.
I'll just clarify, Your Honor. Did you report to the police a name of a specific individual you accused of a crime?
I didn't provide a name, but I provided a picture.
Okay. So did you falsely reported the identity of someone who committed a crime? Is that correct?
That's correct.
Okay.
And that the crime was just reporting was a felony.
Was a felony. Is that correct, ma'am?
I'm sorry, Your Honor. I'm having trouble hearing you. There's some interference with,
I think because
prisoner.
Mr. Schwartz finally became unmuted.
Yes, sir. Yes, sir.
All right.
Yes, sir.
Hold on, Mr. Schwartz.
Okay, sir.
Ms. Bartlett,
Yes.
was the crime that you reported either a felony or a misdemeanor?
Yes, it was a felony.
All right, very good. Well, I can either take the higher one or not. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
January 22nd at 9 a.m.
January 22nd, 2025, 9 a.m. before Judge Perry. Bond will continue. All right, thank you.
Thank you very much, Your Honor.
Unlike Ms. Josephine Bartlett, here's Alicia Brock, stalling the system with an adjournment request while facing yet another round of serious charges for driving while intoxicated.
Court calls the case People versus Letitia. Is it Letitia? Lestacia. Probably. Brock.
Andrew Children's appearing on behalf of the people.
Stephanie Kane with the Public Defender's Office on behalf of Ms. Brock, who's appearing by Zoom. Ms. Brock, could you please state your name for the record?
Alicia Brock.
Your Honor, at this time, we're going to ask for an adjournment in this case. I'm going to ask for a slightly longer one if the court is inclined to grant it of 30 days. It's my understanding that there are new charges pending against my client. I am hoping that we could probably come to some sort of resolution. I'm going to try to do maybe a mitigation letter to help the court or help the prosecutor understand my client's position, Your Honor. So I'm asking for a 30-day adjournment.
Are the charges?
I'm sorry, Your Honor.
You said they're pending.
So, Your Honor, on 12/30, our office issued a new OWI, misdemeanor OWI, second warrant against Ms. Brock. That would not, the date of offense was back in the summer. And I actually saw yesterday that I believe the sheriff's department submitted a new warrant request for another OWI that also occurred in the summer. I don't know what the delay was, but the yeah, that would also be an OWI second.
Is she on a tether?
She is on house arrest for house, Your Honor. If you court remembers, the last time we were here, she indicated that due to charges outside of our county, she is.
Yeah. Is she testing?
Your Honor, I'm not sure. Ms. Brock, are you testing based on the bond conditions for your out-of-county case?
I will be testing twice a month. Probably starting next week because it was the New Year's. So yeah, for my other case, that's what.
So yes, Your Honor, she hasn't started yet, but it's her understanding she will be starting next in the next couple of weeks.
Twice a month.
Your Honor, I will say for the court's information that I quickly reviewed the warrant request submitted yesterday, and the alleged VAC from that incident was 0.4 something, an incredibly high VAC. So I certainly, that was part of my communication with Ms. Cannon, was it appears that her client may have a pretty significant alcohol issue, and I'd like to understand where we're at with that before we work towards any sort of resolution.
Probable cause conference will be adjourned January 16th, 2025, 9 a.m. Her bond will continue, but defendant to report to, or either report to community corrections. Well, report to community corrections. I want her on at least a sober link at this point.
Okay, Your Honor, she is on house arrest right now.
know.
Further, okay. I will get you the order, Ms. Brock. She'll need to take it to your person, okay? But we'll discuss that.
Take it to the person, or we will mail a sober link, but she needs to blow into one.
So do I call them? I tried to call them to set it up, but I don't know.
Ms. Brock, I'm gonna call you now. The court has to move forward. I'll call you.
Okay, thank you.
Finally, here's Amanda Smith admitting to theft and facing the consequences of her actions.
Thank you.
All set. Thank you.
Court calls case People versus Amanda Smith.
After Lonnie for the people.
Just on behalf of Amanda Smith. Amanda, would you state your name for the record?
Amanda Smith.
Judge, today's 10th day for PCC. My client is going to take advantage of the offer offered by Ms. Londy to plead to no.
I have a plea form that indicates she's going to plead larceny 200 to 1,000 to 1 year offense. Upon her successful plea to that charge, no contest plea to that charge, count one would be dismissed.
That's correct, Your Honor.
There is also an indication of no delayed or deferred.
For the record, Judge, my client is on probation in Detroit, Third Circuit, but this case had preceded that case, so I don't believe there'd be a violation of that. We've signed a vice of rights, and I don't know if the judge sentencing waiver was necessary, but we signed it.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Amanda Smith.
Smith, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Two things about it. I have to make sure you understand it. First means that you're not further desirous or wanting to contest these charges. You understand that?
Sure.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Basis for the no contest plea?
A potential civil liability, Your Honor.
All right. To this charge, how do you plead?
Contest, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
Yes, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading, you're giving up those rights as well as all the rights on that form. Yes? You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Pardon?
Yes.
You are, but this offense
Happened way before.
way before you were placed on
Yes.
probation. All right. Has anybody promised you anything other than what's been stated here today to get you to plea? Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will.
Yes, sir.
Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 2200711121. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. before Judge Washington.
February 13th, 2025, 10 a.m. before Judge Washington. Bond continued.
Thank you, Your Honor. I will instruct my client to contact probation department 14B.
All right.
Judge, may I have police report back?
That's pretty much what I got for you guys on this one. Hopefully, you enjoyed the video. If you did, make sure to leave a like and subscribe to the channel. Thanks for watching, and I'll see you on the next one.